Hi there. You're due another congratulations. You've made the difficult decision to keep fighting for fair compensation. For us here at Jason Stone Injury Lawyers, we find we get better results when our clients agree to file a lawsuit and force the insurance company to take us seriously. Sure, we'd prefer that they make an offer that truly compensates you for everything you've lost due to the defendant's negligence, but that rarely happens at this stage. Up until now, we've been playing by their rules because they control the money. By filing a lawsuit, we've brought the potential of a jury verdict into the equation, and a jury can return a verdict for any amount. When insurance companies cannot control the outcome, they often make larger offers. Prior to recommending that we file a lawsuit, I met with your attorney and figured out the strengths and weaknesses of your case. We came up with a plan of attack. Here's a little explanation about what you can expect to happen from here on out. The process of filing a lawsuit begins when we file a document, called a complaint, with the court. We then hire a sheriff to serve the complaint on the party responsible for causing your damages, called the defendant. After the defendant receives the complaint, the defendant's insurance company has 20 days to assign a lawyer and file a document with the court called an answer. Essentially, we make a complaint, the other side answers the complaint. Once a complaint is filed, the rules of civil procedure, the specific rules of that court, and common professional courtesy dictate the process. For example, even though the rules require the defendant to file an answer within 20 days, if the defendant doesn't, many judges would be more unhappy with us for refusing to extend professional courtesy by giving it more time than it would be at the defendant for failing to answer the complaint within 20 days. Once we receive the defendant's answer, our team and their lawyer will exchange written requests for information. This is called paper discovery. During paper discovery, each side gets to see and learn about the other side's claims and defenses. Within 3 months of filing the lawsuit, you, your attorney or personal case manager, will meet for an hour or so to draft your responses to the other side's questions. According to the Massachusetts rules, both sides have 45 days to complete the paper discovery, although often it does take longer. Usually about a month or so after finishing paper discovery, we will start the deposition stage. During this stage, we get to ask the defendant, in the presence of its lawyers, about how its negligence caused your injuries and to explain any reasons why the defendant believes it's not responsible. Around the same time, the defendant's lawyer will want to take your deposition, so it can understand why you think the defendant's actions caused your injuries. You and your attorney will meet as much as is needed to prepare for your deposition. During the deposition, which is usually held in a conference room, you'll be asked questions concerning your background, the effect the injury had on your life, prior injuries, your medical condition, and things of that nature. Typically, depositions last between 2 and 3 hours. The court, not us, sets a deadline by which time all depositions must be completed. Since the insurance companies are constantly trying to delay justice, we are constantly pushing forward, holding the other side accountable to deadlines. Once depositions of all parties and witnesses are complete, the case may settle without further involvement from you. If it doesn't settle, a pretrial conference will be scheduled by the court, during which we receive a trial date. You're welcome to attend the pretrial conference, but it's not required. If we still can't reach an agreement, the final step in the litigation process is to proceed to trial and ask a jury to determine what is fair and reasonable compensation for everything that you've experienced through no fault of your own. Most cases resolve before trial. However, at our office, we always prepare for trial because that's the best way to ensure the case gets settled. Even though there's a lot to it, from your perspective, we only need your help answering the written discovery, preparing for and attending your deposition, and if necessary, preparing for and attending your trial. The rest of the work is done by us without your involvement. It may seem like things are moving a little slowly, and that's 100% accurate. The sooner we've lived up to our litigation obligations, the sooner we can put pressure on the other side. We know you want this portion of your life to be over with, and we'll do our best to hold the other side accountable to deadlines. In the meantime, call us to discuss this further, but we'll be in touch to schedule a meeting once we've been served with the paper discovery from the other side, which should be about 60 to 90 days from now.